Hello everyone, I'm Dr. Kalpana. In this lecture, we would be discussing test of legal validity part 2, which is related to section 23 requirement, which agreements are void. As section 10 talks about which agreements are valid. So this presentation explores the critical intersection of public policy, contract law in India, focusing on agreements deemed to be void under Indian Contract Act. We would explore into Section 10's requirement as already been done in my part 1 lecture. Examining Section 23's provision for void agreement and understanding these principles is crucial for legal professionals, and we'll be checking upon the enforceability and ethical integrity of contractual arrangements within legal framework. So section 10, we have already done with it, which talks about which agreements can be converted into a valid contract, consideration, object, capacity, uh, age of the parties, competent parties, etc. Now, coming to section 23, grounds for voidness. So section 23 elaborates on circumstances under which an agreement's object or consideration is deemed to be unlawful, thereby rendering the agreement void. So these grounds are comprehensive, covering the scenarios where agreements are forbidden by law or would defeat any legal provision, are fraudulent in nature, involve or imply injury to person or property, are regarded as immoral or opposed to public policy. So now coming to what is the doctrine of public policy that has not been defined, and yet it is fundamental. So Indian Contract Act does not explicitly define what is public policy. Instead, its interpretation is rooted in common law principles and judicial precedent. It refers to those core principles and standards considered so essential to the well-being of or moral fabric of the society that any contract contravening them is so automatically declared void regardless of the party's intentions. Judicial restraint and evolution Supreme Court's ruling in Gherulal Parakh versus Mahadev Maya established that the doctrine of public policy is not static. It can expand, adapt in response to the societal changes, evolving moral standards. However, the court also cautioned that this doctrine should be invoked with considerable restraint, preventing arbitrary expansion and ensuring legal certainty in contractual relationships. Now, coming to the provision, uh, which agreements are void in restraint, that is marriage, trade, and legal proceedings. Meaning thereby, in brief, you cannot enter into an agreement which is restraining by promise to marry or trade and restraint of legal proceedings. So according to section 26 of Indian Contract Act, any agreement that restricts person's marriage unless they are minor is void. This principle is highlighted in Low versus Pierce, upholds the fundamental right to marry. For instance, a promise by A to marry B only if B refrains from marrying anyone else for 10 years is unenforceable as it unduly restricts personal liberty. Section 27 makes any agreement void in restraint of trade. Agreements that prevent an individual from engaging in a lawful profession, trade, or business are void. This ensures free competition and individual economic liberty. A notable exception is reasonable restriction imposed during the sale of goodwill as affirmed in Niranjan Shankar Goli Curry versus Century Spinning and Manufacturing Company, which also clarified that negative covenants during employment, if reasonable, are valid. Section 28 makes any agreement void which is in restraint of legal proceeding. Agreement that entirely prohibit parties from enforcing their rights through courts, limits the period for doing so are void. The principle reiterated in Satyanarayan versus Ramnarayan case prevents parties from ousting the jurisdiction of the courts. However, arbitration agreement governed by Arbitration and Conciliation Act are valid exception providing an alternative dispute resolution mechanism. Void agreements for uncertainty, wagering, and impossibility. These are the three grounds which are very important. Agreements with uncertain meaning, Section 29, contracts whose meaning is ambiguous, cannot be determined, are void. As illustrated in Scamel versus Austin, if parties agree to sell 100 tons of oil without specifying the type, the agreement too vague to be legally binding. This ensures the clarity and enforceability in contractual terms. Wagering agreement is governed by Section 30. Agreements by way of wager are void. The key element are promise to pay money based on uncertain event where neither party has interest beyond the winning or losing. The landmark case is Carlyle versus Carbolic Smockball, distinguished the genuine offer from mere wagers, emphasizing the intention to create legal relations. Agreement to perform an impossible act is governed under Section 56. An agreement to perform an inherently impossible act is also void. This impossibility can be initial, like void ab initio, like discovering treasure by magic, or subsequent, where the contract becomes void due to unforeseen circumstances, as in Satyabrata Ghosh versus Mugniram Bangur, which deals with the doctrine of frustration when performance becomes impossible. Beyond explicit additional void public policy, areas agreement to commit a crime, directly illegal and unenforceable, any contract facilitating criminal activity is also void from the outset. Interference with justice administration agreement that stifle prosecution or influence judicial outcomes are void. This ensures the integrity and impartiality of legal system. Marriage brokerage, trafficking, contracts involving payment for arranging marriages, particularly those exploiting individuals, are deemed immoral and void. Such agreements are considered against the public interest in upholding the sanctity of marriage. Defrauding creditors or revenue agreement designed to evade financial obligations to creditors or government revenue authorities are void. This prevents illicit financial dealings and promotes commercial fairness. Judicial prudence, dynamic interpretation of public policy, caution expansion. Courts in India maintain a cautious approach when extending the ambit of public policy. They are reluctant to introduce new categories of void agreements unless it is absolutely essential to safeguard compelling public interest. This restraint ensures predictability and stability in commercial transactions and preventing arbitrary invalidation of contracts. ONGC versus Saw Pipe Limited, Supreme Court's decision in this case significantly expanded the scope of public policy to include patent illegality in arbitral awards. This landmark ruling allows court to set aside arbitral awards that are clearly contrary to the fundamental policy of Indian law, even if not explicitly defined as such, reinforcing the judiciary's role in upholding legality and fairness. Protecting public interest, the primary driver for invoking public policy is the protection of society's broader interests rather than merely individual dispute. This involves balancing contractual freedom with the need to uphold fundamental societal values, ethical standards, and legal norms. Now, to conclude this lecture, pillars of contractual validity in India. Public interest as guiding principle. Legal validity of contracts in India is intrinsically linked with public interest. Contracts must not only comply with the statutory provisions but align with prevailing societal values and ethical considerations, ensuring fairness and legality in all agreements. Fairness and legality doctrines surrounding void agreements emphasize that contracts must be fair, non-injurious, legal in both their objects and consideration. Clarity and enforceability requirement for certainty in contractual terms. The prevention of impossible act ensure that agreements are clear, unambiguous, and practically enforceable. This reduces dispute and provides a stable framework for commercial and personal dealings. Dynamic judicial interpretation. Indian judiciary continues to interpret the doctrine of public policy with balanced approach, flexible enough to adapt to evolving societal norms, yet cautious to maintain legal certainty. This ensures that contracts remain relevant and ethically sound in changing world. With this, I would end here. Happy learning.